Today, my topic is sexual harassment of women at the workplace. Introduction. Women are the most vulnerable and marginalized group in every society of the world. They have often become the victims of violence such as killing, torture, rape, sexual harassment, cruelty, and degrading treatment, amongst others. This is mainly because of the peculiar feature of physical, mental, social, economic, cultural, and political status of women. Sexual harassment is violation every woman faces, an almost daily encounter for women of all ages and backgrounds, on the street, in the buses and trains, or at the workplace. Some call it eve-teasing or harmless joking or flirting, making light of the harrowing experience of sexual harassment. As a result, women are found less educated, ill-health, low paid at the workplaces, sometimes sexually harassed by their employers, superiors, co-workers, etc. Hence, for centuries, the women have been subjected to various forms of exploitation, harassment, and torture, both in physical and sexual capacities. When women entered into the paid labor force from the narrow confinement of the family, they experienced a new kind of harassment at the hands of their employers, supervisors, and co-workers. Women in the workplace experience a wide range of sexual conducts ranging from sexist comments to non-violent sexual contact to violent sexual impositions. Sexual harassment, which was an invisible problem until quite recently, has now become a major social problem with the widespread entry of women into the labor force. Today, almost all working women are vulnerable to sexual harassment irrespective of their status, personal characteristics, and a type of their employment. The experience of sexual harassment is an affront to a worker's dignity and prevents women from making a contribution commensurate with their abilities. The involvement of a more prominent person in outraging the modesty of a senior IAS officer has led many judges to rethink about this pandemic problem in the context of the current remedial measures. Sexual harassment is a multidimensional phenomenon that needs to be studied from multidisciplinary perspectives. Definition of sexual harassment. In Visakha versus State of Rajasthan 1997, Volume 6, Supreme Court Cases, page number 24, the Supreme Court, by relying on the Article 11 of the CEDAW, suggested the definition of sexual harassment. Sexual harassment includes such unwelcome sexually determined behavior, whether directly or by implication, as number A, physical contact and advances, number B, a demand or request for sexual favor, C, sexually colored remarks, D, showing pornography, and E, any other unwelcome physical, verbal or non-verbal conduct of a sexual nature. This definition of sexual harassment has been reaffirmed by the Sexual Harassment of Women at Workplace Prevention, Prohibition, and Redressal Act 2013, where any of these acts is committed in circumstances where the victim of such conduct has a reasonable apprehension that in relation to the victim's employment or work, whether she is drawing a salary or honorarium or voluntary, whether in government, public or private enterprise, such conduct can be humiliating and may constitute a health and safety problem. It is discriminatory, for instance, when the woman has reasonable grounds to believe that her objection would disadvantage her in connection with her employment or work, including recruiting or promotion, or when it creates a hostile work environment. Adverse consequences might be visited if the victim does not consent to the conduct in question or raises any objection against it. An analysis of the above definition shows that sexual harassment is a form of sex discrimination projected through unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct with sexual overtones, whether directly or by implication, particularly when submission to or rejection of such a conduct by the female employee was capable of being used for affecting the employment of the female employee and unreasonably interfering with her work performance and had the effect of creating an intimidating or hostile working environment for her. Thus, any action or gesture, whether directly or by implication, aims at or has tendency to outrage the modesty of a female employee constitutes sexual harassment. Even an attempt of molesting would be sufficient to constitute sexual harassment. Cases of sexual harassment. The term sexual harassment entered public discourse with the high-profile protest by one lady IAS officer. In 1988, she began her struggle to establish that one senior police officer had harassed her sexually at an official party. She faced an uphill task with the courts reluctant to convict the senior police officer. It was only in 2005 that his conviction was upheld in the Supreme Court. But it was the brutal gang rape of a village-level social worker employed by the Women's Development Program in Rajasthan by 5 men against her carrying out her job of raising the status of women around the village. Women's group worked closely with the social worker to seek legal justice for her. With caste biases rife in the judiciary, justice eluded the victim and the rapists were acquitted. Alongside Vishakha, a Jaipur-based women's group along with other women's organizations filed a writ petition before the Supreme Court seeking legal framework to deal with sexual harassment that inhibits women in the workplace. The writ petition has been filed for the enforcement of the fundamental right of working women under Article 14, 19 and 21 of the Constitution of India in view of the prevailing climate in which the violation of these rights is not uncommon. The incident of the gang rape of the social worker reveals the hazards to which a working woman may be exposed and the depravity to which sexual harassment can degenerate and urgency for safeguards by an alternative mechanism to fulfill this social urgent need in the absence of the legislative measures. Sexual harassment results in the violation of the fundamental rights of gender equality and the rights to life and liberty. It is clear violation of the rights under Article 14, 15 and 21 of the Constitution. It is also the violation of the victim's fundamental rights under Article 19(1)(g), that is, to practice any profession or to carry out any occupation, trade or business. The fundamental right to carry on any occupation, trade or profession depends on the availability of a safe working environment. Right to life means life with dignity. In 1997, the Supreme Court passed a landmark judgment, often referred to as the Vishakha's guidelines, that sexual harassment at the workplace violated women's equal rights. It defined sexual harassment in the line with the Convention on the Elimination of Discrimination Against Women principles and recommended that the employer should constitute a committee to redress complaints and ensure a conducive work atmosphere. The Supreme Court laid down the guidelines, laying down the principles. Number 1, the employer will be duty-bound to prevent or deter the commission of acts of sexual harassment. Number 2, appropriate steps would be taken to prevent sexual harassment without prejudice the generality of said obligation. Number 3. Appropriate works conditions should be provided in respect of works, leisure, health and hygiene to further ensure that there was no hostile environment towards women. Number 4. Where any such conduct amounts to specific offence under Indian Penal Code, the employer shall institute appropriate action according to law. Number 5. Where such conduct amounts to misconduct in the employment, appropriate disciplinary action should be initiated. Number 6. Appropriate complaint mechanism should be created in the organization of the employer. Number 7. There should be a complaint committee which should be headed by a woman and not less than half of its members should be women. Number 8. Where sexual harassment occurs as a result of act or omission by any third persons. These guidelines will not prejudice any rights available under the Protection of Human Rights Act 1993. Accordingly, the Supreme Court directed that the above guidelines and norms would be strictly observed in all workplaces for the prevention and enforcement of the rights to gender equality of the working women. These directions were binding and enforceable in law till the enactment of the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. In the case of Apparel Export Promotion Council versus A.K. Chopra, AIR 1999, Supreme Court, page number 625. Again, the Supreme Court reiterated the Visakha's ruling and said that the attempts of sexual harassment of female results in violation of fundamental rights to gender equality enshrined under Article 14 and 21 of the Constitution. The court further stated that the international instruments such as the Convention on the Elimination of All Forms of Discrimination against Women and the Beijing Declaration cast an obligation on the state to take appropriate measures to prevent gender inequalities and protect the honor and dignity of women. The role of the court in laying down guidelines for public and private employers in order to curb sexual harassment is well acknowledged. The fact that these guidelines have been in operation for 15 years and only in 2012, the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013 was enacted, which points to dynamic role of courts in enforcing equal opportunity to women at workplace in compliance to the International Convention Against Discrimination. International Convention and Sexual Harassment. Gender equality includes protection from sexual harassment and right to work with dignity, which is an universally recognized basic human right. The common minimum requirement of this right has received global acceptance. Some provisions included in the Convention on the Elimination of All Forms of Discrimination against Women are as follows. Article 11. State parties shall take all appropriate measures to eliminate discrimination against women in the field of employment in order to ensure, on a basis of equality of men and women, the same rights in particular. Article 11A. The right to work as an inalienable right of all human beings. Article 11F. The right to protection of health and to safety in working conditions, including the safeguarding of the function of reproduction. Article 24. State parties undertake to adopt all necessary measures at the national level aimed at achieving the full realization of the rights recognized in the present convention. In this context, the general recommendations of CEDAW in respect of Article 11 are violence and equality in employment. Article 22. equality in employment can be seriously impaired when women are subjected to gender-specific violence such as sexual harassment in the workplace. In 1993, at the ILO seminar held at Manila, it was recognized that sexual harassment of women at the workplace was a form of gender discrimination against women. The message of international instruments such as the Convention on the Elimination of All Forms of Discrimination Against Women 1979 and the Beijing Declaration, which directs all state parties to take appropriate measures to prevent discrimination of all forms of violence against women, besides taking steps to protect the honor and the dignity of women, is loud and clear. The International Covenant on Economic, Social and Cultural Rights contains several provisions particularly important for women. Article 7 recognizes her right to fair condition of work and reflects that women shall not be subjected to sexual harassment at the workplace which may vitiate working environment. These international instruments cast an obligation on the Indian state to gender sensitize its laws, and the courts are under an obligation to see that the message of the numerous cases emphasize that while discussing constitutional requirements, courts and the council must never forget the core principle embodied in the international conventions and instruments, and as far as possible give effect to the principles contained in those international instruments. It is to be noted that the Government of India has ratified the CEDAW resolution on 25th June 1953 with some reservations, which are no material in the present context. At the 4th World Conference on Women in Beijing, the Government of India has also made an official commitment inter alia to formulate and operationalize a national policy on women, which will be a continuous guide and inform action at every level and in every sector, to set up a commission for women's right to act as a public defender of women's human rights, to institutionalize a national level mechanism to monitor the implementation of the platform for action. The Sexual Harassment of Women at the Workplace, Prevention, Prohibition and Redressal Act 2013. The Sexual Harassment of Women at Workplace, Prevention, Prohibition, Redressal Bill was passed by the Parliament and received the assent of the President on 22nd April 2013. It came on the statute book as the Sexual Harassment of Women at the Workplace, Prevention, Prohibition and Redressal Act 2013. This is an act to provide protection against sexual harassment of women at workplace and for the prevention and redressal of complaints of sexual harassment and for matters connected therewith. Section 2A of the Act defines aggrieved woman, which means in relation to a workplace, a woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent. In relation to a dwelling place or house, a woman of any age who is employed in such a dwelling place or house. Section 2H defines internal committee as internal complaints committee constituted under Section 4. It is also provided that the presiding officer of the internal committee shall be a woman and at least half the total member of the committee shall be women. Section 2I defines local committee as the local complaints committee constituted under Section 6 of the Act. According to Section 9 of the Act, any aggrieved woman may make in writing a complaint of sexual harassment at workplace to the internal committee or the local committee within a period of 3 months from the date of the incident. According to Section 10, the internal committee, before initiating an inquiry and at the request of the aggrieved woman, takes steps to settle the matter between her and the respondent through conciliation. According to Section 11, the inquiry shall be completed within 90 days. According to Section 13, the internal committee or the local committee arrives at the conclusion that the allegation against the respondent has been proved. It shall recommend to the employer or the district officer, number 1, to take action for sexual harassment as a misconduct in accordance with the provisions of the service rule applicable to the respondent. Number 2, to deduct from the salary or wages of the respondent such sum as it may consider appropriate to be paid to the aggrieved woman or to her legal heirs. Section 16 of the Act provides for determination of compensation to be paid to the aggrieved woman. The internal committee or the local committee shall have regard to a. the mental trauma, the pain, suffering and emotional distress caused to the aggrieved woman. Number B, the loss in career opportunity due to the incident of sexual harassment. Number C, medical expenses incurred by the victim for physical or psychiatric treatment. Number D, the income and financial status of the respondent. And number E, feasibility of such payment in lump sum or in installments. Conclusion. Sexual harassment at workplace is considered violation of women's right to equality, life and liberty. It creates an insecure and hostile work environment which discourages women's participation in work, thereby adversely affecting their social and economic empowerment and the goal of inclusive growth. Indian Constitution embodies the concept of equality. Article 14 and 15 prohibits discrimination on the ground of religion, race, caste, sex or place of birth or any of them. Article 19(1)(g) gives the fundamental rights to all citizens to practice any profession or to carry on any occupation, trade or business. This right presupposes the availability of an enabling environment for women which is equitous, safe and secure in every respect. Article 21 relates to the right to life and personal liberty, which includes the right to live with dignity, and in case of women, it means they must be treated with due respect, decency and dignity at the workplace. The enactment of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 is a big step forward for protecting the fundamental rights of women by providing a safe, secure and enabling environment to every woman irrespective of her age or employment status.